Hello and welcome to Trusts and Estates Weekly. My voice is changing, which is strange because I'm really no longer a teenager. Let me get myself into frame here better. I'm your host, Kevin Bemmel, and we are here every Monday morning, 10 a.m. Pacific time and 1 p.m. Eastern time, with an hour in for Central and Mountain time. And we discuss all things related to trusts, estates, probate, both on the planning side for you and your own estate planning, and also from the standpoint of professionals who are interested in helping people with their estate planning and the execution of those plans. So today I'm going to talk about the common mistakes that are made in estate planning. And I have my trusty PowerPoint here, which makes it easier to follow along. In case you're wondering why I typically do a PowerPoint, it's because when it comes to learning things, people learn better when they see and hear the information. And so this is designed to help you absorb what we're talking about more thoroughly. And also, do you really want to look at, this the whole time and nothing else? This beautiful sort of, picture of wood has got to be better than looking at me for the whole show. Anyway, Trusts and Estates Weekly, here we go. And as always, we are here in the pursuits pillar of the 3 pillars of attainment, dealing with finances. And here we go. So we're going to look at how you avoid common estate planning mistakes. Okay, so the first thing that you want to keep in mind is, in many, many cases, an estate plan is going to need more than one part. So you want to make sure that it's comprehensive. Okay, now you almost for sure are going to need a will. Okay, not always. And if you go to our YouTube channel, you'll see I did a show, I think it was 2 weeks ago, on ways to avoid probate. So if you have very little property and it's the kind that can pass to your beneficiaries outside of probate, so you may not even need a will. That's going to be something that you're going to have to look out for your individual circumstances. But most of us are going to need at least a will. Okay. And as we've talked about again in previous shows, a will is a document that designates what's going to happen with your property after you die. So presumably it's going to go to your heirs. In the absence of any of these, the state in which you live is going to decide who gets your property. And again, I've done a show on intestate succession. That means intestate means without essentially any kind of document describing or not describing, but designating who it is gets your property. Okay, so you're probably going to have some kind of will. Now, in many cases, you may also have a trust. Typically, it's going to be probably a living trust. Now, again, this is just general information. This doesn't necessarily apply to your specific situation. You're going to need to get professional advice based on what kind of property you have, how many heirs you have, what kind of value those properties have. All those kind of things are going to play into what kind of documentation you're going to need in a comprehensive estate plan. Now, here in California, for example, if you own a house, you're probably going to need a trust, a living trust, okay? Because if that house has any amount, if it has, not literally any amount of equity, but if you've built up some equity over the years, so it's going to pull you into probate pretty quickly unless you have a trust that designates what's going to happen with that house when you pass away. and making sure that it passes to your heirs outside of probate, and therefore you avoid the costs and time associated with probate. Okay. Now, let me quickly add that just because you have a trust doesn't mean you don't need a will. So in my estate plan, I have both a trust and a will. They are for different purposes. Okay. And so when you do your estate planning, your advisors are going to look at your overall situation. And like I said, you may end up doing both. Now, last week, we talked about powers of attorney. Okay, and a comprehensive estate plan may also mean that you need a power of attorney. So, for example, you may have a springing power of attorney. And again, if you want to go to our YouTube channel, I talk about different types of powers of attorney in more detail. But a springing power of attorney is a power of attorney that becomes active when a particular event happens. Okay, so for example, you can have a type of durable power of attorney called a springing power of attorney for healthcare decisions, I should say. And that power of attorney, okay, sits dormant until something happens in your health that causes it to spring into action, in essence. Okay. So, and by the way, there may be needs for other powers of attorney depending on your situation. Okay. And you may designate an attorney in fact, which is the power of attorney designates someone as your attorney in fact, someone to act in your stead. Okay, act in your place. Now, you, as part of a comprehensive estate plan, you may decide to appoint a power of attorney to handle certain matters. Okay, because I don't know, you want to do a lot of traveling, for example, and you don't want, and you're concerned about day-to-day matters being handled in your absence. So perhaps you'll want a power of attorney for someone to handle that. And that way, you know, when you're out of the country or whatever, traveling around, you don't have to worry about all the day-to-day stuff. Okay. And then, you know, that power of attorney may be limited. And so if there's a significant decision that has to be made, so then your attorney, in fact, will need to get in touch with you, and that'll have to be dealt with. And, you know, maybe a significant issue only comes up, you know, once in a while. And so for the most part, the power of attorney allows that person to act on your behalf. It's no big deal, right? And you can go on with your life. Okay. Finally, you may need healthcare directives. Now, a springing power of attorney is a type of healthcare directive, and there may be others. You know, what's going to happen if you're incapacitated? How is that going to be handled? How are you going to handle a situation where perhaps you're rendered into a state where the doctors think that you're in a coma, you're never going to recover. They're keeping you alive on life support systems. You know, are you going to have do not resuscitate orders? Are you going to remove life sustaining technology at some point? All of those may need to go into healthcare directives. And by the way, if you don't want those things to happen, that may need to happen as well. So if you want all extraordinary means used to keep you alive, right? Maybe you have a religious imperative that requires that you handle your healthcare in that way. So then you're going to want your healthcare directives to reflect those religious values that you have, and make sure that in the event you do become non-responsive, nonetheless, they won't, pull the proverbial plug on you or something like that. Now, I appreciate these topics can be uncomfortable, and I don't mean to make light of them. I just want to kind of keep the tone of this a little bit on the lighter side, because no point in us depressing each other over these matters. They are, the inevitabilities of life, and as adults, we need to face up to them and deal with the situations that we may be faced with, and just and then we can go on with our day, so to speak. Okay, so that is one common estate planning mistake we want to avoid. A second is we want to do regular updates to reflect changes. Okay, so once you have a comprehensive estate plan, that doesn't mean that you're done. It's like, okay, well, I've done that. Now I don't have to worry about it anymore. No, that's not the case. Okay, changes may require that you update or at least change your estate plan. So your personal circumstances may change. So for example, you may acquire another property. Maybe you buy, a second residence in some place where you really like to go on vacation. Okay. Well, you got to make sure that that residence is, if you have a trust, transferred into your trust. If you have a will, you got to make sure that it's addressed in your will. Okay. Maybe you sell a business, and maybe your will or trust was set up so that one heir got the business and the other maybe got some other investments, and now that the business is sold, okay, in essence, that heir who was going to get the business has been disinherited because the business has now been converted into other types of investments. Okay, so it may be that you need to update your how your beneficiaries are treated. Okay, and then all of the attendant documents that go with that. Okay, so personal circumstances can change, and that means you need to at least consider, will the change in those personal circumstances necessitate updating my estate plan? Next, tax laws change. Okay, so well, we talked about this a few weeks ago. The lifetime gift exemption, I believe, is changing. I want to say at the end of 2025. I think the estate value exclusion is also going to change around that same time. Okay, so the fact that tax laws may be changing in a year and a half, or maybe it's 2.5 years, so that may necessitate reviewing your estate plan and potentially making some changes. Okay, and I'll talk a little bit more about that, I think, in the next slide or two. All right, but the fact of the matter is that tax laws do change periodically. So even if your estate plan is already done and it's been good for the last, whatever it's been, 5-10 years, that doesn't mean that going forward it can just stay that way. You may very well need to make some changes based on changes in the tax law. Now, it can be a little bit difficult, right? Because sometimes tax laws change automatically, and then right before they change, Congress passes an extension or something like that. So this is why you want to talk to your advisors, talk to people who are following these issues and know a lot about them, and get their advice on what it would be best for you to do. Finally, family dynamics can change. Okay, so God forbid, maybe one of your beneficiaries passes away. Is that going to affect your estate plan? Okay, maybe one of your beneficiaries gets married, or maybe one of your children has children, so now you have grandchildren, or maybe your grandchildren have children, now you have great grandchildren. Do you want to change your estate plan to take into account that next generation? Okay, maybe you want to set up, or allocate money for college for them or something like that, or maybe you want to set up a 529 plan for them now. Okay, which again, that may necessitate changes in your broader comprehensive estate plan. Okay. Now, maybe you've had a falling out with someone in your family. Okay. And maybe you want to disinherit them. Those things happen in any family. They can happen, right? So if that's the case, it's not enough to intend to disinherit them. The documents have to reflect that. And in many cases, to sustain the disinheritance, the documents have to specifically say, I intend for this individual to not get anything. Otherwise, that person may, if your documents are silent about them, that person may still retain a claim. Again, these things can vary by state. So if that's something you intend to do, talk to your lawyer, talk to your financial advisors. How do you best deal with this? Now, the fundamental purpose for doing regular updates to reflect changes is to avoid unintended consequences and disputes. Okay, so for example, let's say that you want to disinherit one of your children, okay, but it's not specific in the documents that they're disinherited. You had originally intended them to get certain assets, and you just pulled their name out. Okay, well, when after you pass away, your children who you do want to inherit could end up in a dispute with the disinherited child because it's not clear that that's what you intended. Okay, and now all of a sudden your estate could be subject to legal fees by having to fight that claim by the disinherited child because it wasn't clear. Okay. By the way, the same thing could happen. Let's say you were estranged from a child and you patched things up, and now you want the child to inherit. Okay, but that wasn't specifically set up in your estate plan either. So after you pass away, I hate to say it, but I've seen cases where children fight each other tooth and nail in order to get a larger share of the assets of their deceased parents. So any change in family dynamics should be examined to determine if it requires a change in any of the documents in your estate plan. All right, let's go to the next one. Oh, oops, I went the wrong way. What am I doing here? I'm hitting the wrong buttons. Okay. So, next, asset titling and beneficiary designations. Okay, so some assets can pass to heirs without having to go through probate and without necessarily having to be in a trust. And that can be very beneficial. For example, retirement plans, they can be set up in a way that when you die, they go to your heir, okay? But they've got to be titled properly, meaning the account vesting has to be set up properly, and the beneficiaries have to be set up properly, okay? And again, I keep emphasizing this. All of this is handled by state law, and the law is not the same in all 50 states, plus the territories. So all of this needs to be done in accordance with the state in which you're a resident, generally speaking. Okay. By the way, though, if you've got assets in another state, it's well to check out. Do you have to comply with that other state's rules as well? Okay. So I wouldn't leave anything to chance. The extra couple of hours it may take of attorney's time to check these things out could save a big problem down the line for you or your heirs. Okay, so life insurance policies, again, life insurance policies generally, they don't go through probate. They don't go into a trust. Sometimes they're set up to pay estate taxes. Sometimes they're set up in order to provide somebody that you leave behind with the assets they need to be able to continue their life. Okay, beneficiaries need to be properly designated. They need to be kept up to date. Okay, and all of that needs to be reviewed periodically, just as the other issues we were talking about a moment ago. Okay, investment accounts. So sometimes investment accounts can have what's called a transfer on death function, where you own it during your lifetime, and then once you die, your heir, the beneficiary of the account, will submit a copy of the death certificate to the account holding company, and it will transfer to the beneficiaries on death. It doesn't have to go through probate, doesn't have to be in a trust necessarily. Okay, so that's another issue with that. That's an issue of, again, both titling, how the account is vested, and also making sure that beneficiaries are designated properly. Okay, now I'm going to take a step back, because we're under kind of a presumption of your estate plan is already in effect. But indeed, some of these things apply if you're in the process of setting up your estate plan. So one of the common mistakes that estate planning attorneys will tell me about is they'll set up a trust for their client, and then the client will never transfer assets into the trust. Okay, so that they have a house, the house remains in their name, as an individual. And if that's the case, the benefit of the trust is lost, because in order for the benefits of the trust to be realized, the assets, the title of the assets has to be put in the trust's name, not kept in the individual's name. Okay, and so there's going to have to be deeds prepared in some cases, depending on what the asset is. If for example, if it's real estate, and bank accounts and such are going to have to be retitled into the name of the trust, so that the account vestings are the trust. Okay, so all of that is part of both setting up a proper estate plan as well as keeping an estate plan up to date. Wow, time is zooming by. Okay, here we go. Minimize taxes and estate costs using trusts, gifting strategies, and charitable giving. Okay, so I mentioned earlier, one of the reasons for setting up a living trust is you can typically avoid going through probate, which should save on the costs of administrating the estate. Okay, now I talked about this a few weeks ago. I don't remember exactly when. Property that's in a trust does not escape being included in the gross value of your estate for estate tax purposes. Okay, so that all by itself won't minimize estate taxes. However, there are gifting strategies and charitable giving strategies that can minimize estate taxes. Okay, so during your life, and again, I refer you to my YouTube channel, where we talk about gift taxes and how all that works. You can give, I believe it's $20,000 a year to any individual you choose. And if it's a married couple, husband and wife, so then you've got $40,000 a year that you could give to them over your lifetime. Okay, and that amount that you give to them is subtracted from your lifetime gift exclusion, but still that may help you minimize, or that may help really your beneficiaries minimize estate taxes at the point where you pass away. Okay, same with charitable giving strategies. Okay, so especially if you have a large estate, several millions of dollars. Okay, where especially if the law about exemption on the amount exempted from estate taxes changes, and that an amount goes down, this is something you may want to be taking a look at now to see, do you need to come up with some kind of gifting or charitable giving strategy that will help you perhaps stay under that estate tax exemption level. Okay, So that's something I would to talk to your attorney about, your financial professionals, etc. Okay, finally, you want to communicate and get professional guidance. I've said this throughout this. You want to make sure you're getting professional guidance, so you're doing what makes sense for your specific situation. These common estate planning mistakes that I've been talking about here for about the last 25 minutes, they are common. They may or may not apply to you as an individual, or you and your spouse as an individual, okay? It depends on your situation. So you want to do basically two things. One is communicate with your family members so they understand your intentions. Okay. Now, you're going to have all these documents, but no matter how clearly the documents are written, they're not always going to be 100% clear. In fact, in most cases, they're not going to be 100% clear. So by talking to your family members, making it as clear as you possibly can how you want your estate handled after you pass away, that will increase the likelihood that your wishes will be carried out after you're gone. Okay, and two, it can potentially prevent disputes between family members if all family members know what your wishes are. Okay, so sit down with them, explain it to them, make sure that they're up to date about the various issues of concern to you. Okay, and be as open as you can about them. Next, attorneys, financial advisors, fiduciaries, make sure that you are consulting with these people, especially as your estate gets larger. The more likely it is that you're going to need advice from this kind of professional guidance, this kind of professional advice. Okay. Attorneys who specialize in estate planning and taxation, financial advisors who have a background in dealing with estate planning matters, probate, etc., and fiduciaries. Okay, so for example, I'm a professional fiduciary. One of the things I do is administrate trusts and estates, for other people. Okay, so include all of these people in your estate planning plans, right? To make sure that they understand what it is your intentions are, and to make sure that they've got as much information as they can have in helping get documents drawn up and helping execute your wishes, all of these things. Okay, so the extra hour you take with your professionals, while you'll pay another hour of their fees, that could make the difference in making sure that your wishes are carried out after you're gone. Unfortunately, we're all going to pass away at some point, and once we're not here anymore, there is no way for someone to definitely know what we want to happen, and so we've got to plan for that eventuality, as unpleasant as that is. I'm sorry, this is the last one here. So we tailor to the correct and specific jurisdiction. I did mention this earlier, so I won't spend a lot of time on this, but laws vary by state or region. Region would be like Puerto Rico has its own laws, Guam has its own laws, okay? And for the most part, the law you're going to be dealing with is state to state. Now, estate taxes happen on both a federal and a state level, okay? So you're going to be dealing with both. Okay, but generally speaking, you're going to be dealing with state law. If you change your state of residence, that may necessitate updating your estate plan. Okay, and a lot of people have been mobile during COVID, or a lot of people, I should say, were mobile during COVID. They changed what state they're living in. And so you want to make sure that your estate plan is up to date, so it's tailored to the specific jurisdiction in which it needs to be dealt with. Okay, I think that's the last one. Yes, it is. Okay, so if you want help, here's places to contact me. All of this information will be in the show notes. And so if you have a question, you can drop it in the comment sections on social media. You can always send me an email. I'm happy to hear from you. If you have, like I said, questions, if you have comments, good or bad, always interested to hear what you have to say. And here is the legal stuff. So we'll close out of that. And here you go. see, really, do you want to look at this the whole time? No, weren't the pictures much nicer than this punam, as we say in Yiddish? So I want to thank you very much for joining me. I hope you found this useful. And if you're, I went pretty fast because we only spent about a half an hour together on Monday mornings. So if you want to look at it again, please go to my YouTube channel. It'll be posted there in just a few minutes after we sign off from the show, and you can rewatch the episode. You can kind of scroll through it quickly to see the various slides if you want to take notes on those, so you can ask your advisors about these various issues. Encourage you to do that. And if you'd like to send me an email, I'm happy to send you a copy of the PowerPoint presentation. If you want to send it to your the professionals with whom you deal and just say, hey, I saw this thing here and it's only about a half an hour long. Maybe you could just kind of scroll through it in five or 10 minutes and see, does any of this apply to my situation? And if so, let me know, because we'll need to talk. Okay, so that's our show for today, Trust and Estates Weekly. Just real quickly, tomorrow is my show, Business Lessons from the Military. We're continuing our discussion of Marine Corps warfighting doctrine and applying it to business. So I invite you to join me at 11 a.m. Pacific time tomorrow. And then on Wednesday is my show, People Making Money. That's at 12:30 p.m. Pacific time. And I'm going to be talking about how to analyze an investment property quickly. So this is a technique that I learned actually several decades ago from a wonderful professor at UCLA Extension by the name of William Golden. Professor Golden retired quite a number of years ago now. And in fact, I had the honor of taking over teaching that class after he retired. I taught it for many years, and I taught my students what I had learned from Professor Golden. I wish I had kept in touch with him. I don't even know if he's still alive, but I'd like to mention his name because great teachers they are so powerful, and he had an impact on my entire career. I've adapted what he taught me in ways that work better for me. And I'm going to show you that on Wednesday, and it literally will allow you on one spreadsheet that's basically about 8.5 by 11 to analyze and invest all aspects of an investment property very quickly. So I invite you to join me for that on Wednesday. And then next week on Monday, we'll be back here again at 10 a.m. Pacific time for the next edition of Trust and Estates Weekly. Want to thank you once again for joining me. Wish you a wonderful rest of the day, and just sign off by saying, as I always do, Marie, darling, you are my belle. All the best, folks.